What is a civil protection order?
A CPO in the District of Columbia is a court order that requires you to stay away from another individual for 1 year. It is also referred to as a restraining order, protective restraining order, and temporary protective order, TPO. At Rollins & Chan Law Firm, we have handled hundreds of CPO cases in the District of Columbia, and we aggressively defend or pursue civil protection orders for respondents and petitioners. There are specific rules that must be followed in a CPO. I was just served with the temporary protective order. What is that? The temporary protective order, TPO, is an order issued by a judge after the petitioner makes an allegation of domestic violence. It is temporary and usually can only last for up to 14 days. It is temporary because you've not had an opportunity to respond. What kind of allegations are made in a CPO? The petitioner, also referred to the person that's filing the restraining order, must allege that you committed an intrafamily offense. In other words, that you committed criminal acts such as assault, threats, harassment, stalking, unlawful entry, just to name a few. Do I have to be related or know the person that has filed the petition? The petitioner must state that the person who committed the act is related by blood, adoption, legal custody, marriage, or domestic partnership, or with whom the offender has a child in common with. The person does not have to be related if the criminal offense alleged is stalking. What if the person who is seeking the CPO is lying? The person has to prove that you committed a criminal act to the judge. The judge usually wants to see some corroborating evidence from the petitioner. This is why it's important to have your evidence lined up before the hearing. What are the consequences of a CPO? Consequences of a CPO in the District of Columbia. Although a CPO is civil in nature, it may have severe collateral consequences. For example, if the respondent is on probation or parole, allegations contained in the petition, if proven in an evidentiary hearing, have criminal elements to it, it may impact the respondent's probation parole status. Also, such an order is relevant to any future custody case. In the District of Columbia, there is a presumption of joint custody. There is a presumption that both parents are fit and capable of assuming custody of any minor children. However, if there is a CPO entered against one party, the presumption is rebutted. That means the respondent will never stand equal footing with the petitioner relating to the custody of the children. If you consent to a CPO, this presumption is not rebutted. The respondent maintains his ability to seek joint and legal custody of the children. How do you resolve a civil protection order? One of the benefits of hiring a lawyer is because a lawyer can be creative in resolving these types of cases. A civil protection order or final order is issued by a judge after one of the following happens. There is a court hearing where you and your accuser appear and present evidence to the judge. The standard of proof is preponderance of the evidence. You can also consent with admissions, you can consent without admissions, or you can reach a civil agreement to dismiss the case. Do I need to hire an attorney? This is a civil case, so there is no right to an attorney because your liberty is not in jeopardy. You should hire an attorney because of the collateral consequences. If you hire an attorney, there are ways of resolving the case that may dismiss it. Do you have the ability to draft a civil agreement? One of the alternatives that we seek is a civil agreement between the parties. Putting the right language in the civil agreement is something an experienced civil protection lawyer can do. Do you have the ability to try a case? Have you ever tried a case? Most people have seen Law & Order. This is not Law & Order. Advocating for oneself in a courtroom is not as easy as it sounds. Most people that come to us are professionals in their respective field, and we ask them the same question back to them. Does someone need to hire you, or can they do it themselves? The other reason you probably should hire a lawyer for a civil protection order is because the personal nature of the hearing. This is not a small claims case where you're seeking to get some money. This is a hearing where someone is trying to get the court to order a stay away and possibly a set of conditions. Furthermore, the court could order you to perform a multitude of tasks during the year. you have to know the rules of the court. Going in without the requisite knowledge of hearings can be very dangerous. At the very least, you should review the rules of the court for CPO hearings. The District of Columbia Superior Court domestic violence rules spell out what the court can and cannot do during the hearing. You should be familiar with these rules if you decide to represent yourself. You can find us at www.rollinsandschan.com or reach us at 202-455-5610. Thank you.